12:04 in the afternoon here on 90.3 FM. It's Wednesday, and that means it's Joe Steckler Day. Helping Seniors of Brevard is on the air right now, and here's your host of the show, Joe Steckler. Hi, Joe.
Morning, John, or afternoon, John, and thank you, listeners, for being on the air with us. And I guarantee you're going to learn some things this morning or this afternoon on the show, so you might as well get that pencil and paper ready to go. And the phone number in case you want to call, because Bill Johnson's on with us today, and we're going to talk about advanced directives. But it's extremely important that you find out more about the topic that we're going to talk about today. And the phone number here is 722-9998, 722-9998. Before we even get to the show today, I want to tell you that, and I asked Bill to talk a little bit more about it, but they're going to have the actual second event over at Zahn Beachside Assisted Living. And many of you may not know it, but there is a new senior resource center over in Zahn Beachside Assisted Living, and we're going to put on seminars over there on the Kerry can correct me, second Wednesday and fourth Thursday of every month.
That's exactly right.
I got it right for once. But we actually had the first one last Wednesday, and we tried to get advertising out on it, and I just wasn't sure how many people were going to show up. But we had pretty close to a full house, and it'll hold about 80 people. Mm-hmm. And I'm not exaggerating. But what was interesting to me was the way we did the seminar. We had a panel of 6 people, and they all introduced what they did, and then opened it up for discussion, and people got a chance to ask questions, and it just made it a little different type of thing. It wasn't just one person. It was a panel of 4. So having what I've just said, Bill, and with me in the studio today are Bill Johnson. Bill's an elder law attorney, and he is one of our sponsors. Been my longest sponsor on the air with me. We go back many, many, many years, and don't even want to talk about that number. But the other person is Kerry Fink. Kerry is our director of media relations for Helping Seniors. So with that, Bill, before we even get into advanced directives, tell people a little bit about what's going on over there at Zahn Beachside tomorrow, because I think that if people hear from you what you're going to talk about, you can you can still call. I'm sure there's room, and make the phone call.
Okay, well, tomorrow we have a DNR special meeting. We're going to talk about DNRs, life support, end-of-life, hospice, surrogate decision-making, guardianship, and best practices. And this event is put on by the Florida State Guardianship Association. As you mentioned, it'll be at Zahn Beachside Assisted Living, which is at 1894 South Patrick Drive in Indian Harbor Beach. And if you're interested in coming, you can call 321-720-5961, or you can email robin@solutionsbyrpm.com. And that phone number again is 321-720-5961, or robin@solutionsbyrpm.com. And we will have a panel discussion, including the Honorable Lisa Davidson, the Chief Judge of the 18th Judicial Circuit. We'll have Anthony Palmieri, who is the Deputy Inspector General and Chief Guardianship Investigator for Clerk and Comptroller of Palm Beach County. We'll have Kathleen Cashow, I hope I'm pronouncing that right, who is a nurse and General Manager of Vitas Healthcare, and then myself will be on that. It'll be moderated by a lady by the name of Robin Feemeister, who is the President of the Florida State Guardianship Association and a local professional guardian. And this event sponsored by the Brevard County Bar Association, the Florida State Guardianship Association, Space Coast Chapter, the Space Coast Guardianship Association, the law firm of Krasny and Detmer, and, of course, Zahn Beachside Assisted Living and Memory Care. So it should be a good event. We have a lot of people coming. So RSVP immediately because space is limited.
And having said all that, folks, I know the bill has probably intimidated you by that array of people that are going to be sitting up there in front of you. But I assure you that I'm finding that as I go to more of these things and the way they're conducted, they're down to earth. They're not highfalutin. They're something you can understand, and they're something that will help you be better prepared to make some decisions. And as I told Bill when I asked him a couple of days ago what he wanted to talk about today, and he said he'd really like to talk about advanced directives because it's something he's going to talk about on the panel discussion tomorrow. But and then I said, fine, let's do that. And over the years, we've done so many. I probably have done more shows with Bill and Dr. Sheldon than any other people. And I've kept almost all the shows that I did with Bill and Dr. Sheldon. And I could probably go back and what we're going to talk about right now, we probably talked about 10 years ago. But there probably are changes. Not probably are. There are changes. And I'm going to ask some questions of Bill during the conduct of the show. But, folks, I started looking into what Bill was going to talk about. And it's a world of legal experiences, things that we really need to know that are not complicated at all once you're able to sort of put them in a corner and understand them, Bill.
That is true. The sad part is, if you recall, years ago we had that Terry Schiavo case where we had the young lady who was under a guardianship over in the Tampa area, and she ended up having a heart attack. It was unclear what caused the heart attack, if it was allergic shock or something. But she was in a persistent vegetative state, but she had not done any advanced directives, and that's how obviously she ended up in a guardianship. And subsequently, there was a push to terminate the life support, which was keeping her alive, and that erupted into a huge legal battle with the husband being pitted against his in-laws, and then the state of Florida got involved, and they were filing things, briefs, and trying to block that. And so even after that whole thing, which was all over the news, national news even, only 30% of Americans have advanced directives.
Okay, but there's something about
and that number really didn't budge, even as a result of that.
Yeah, but one thing, Bill, that people don't, and we never really talk about this part of it, was the fact that Terry Schiavo was a young person. And most people, when they're young, don't think they need these types of directives.
Well, that's an interesting fact, because if you want to have a really good legal battle, you will have it over a young person. That's why these all become sensationalized or in the news. There's obviously the Terry Schiavo case. There's the Nancy Cruzan case. And then they're drawing a blank, but there was the case out of Illinois, which was Nancy Cruzan was in a car accident, and I think that was a Nebraska or Oklahoma case. I'm not positive. And then the one in Illinois, I can't recall the lady's name, but it was a drug overdose, and she ended up in a persistent vegetative state. And the one thing all three of those ladies had in common, they were all under 30.
Right. Wow. And so when we're young, we think we're invincible, and we don't prepare for what can happen and what we just don't expect to happen. The other thing, as I think about, is on the all these cases. They happen. You mentioned 3 different states.
Right.
What you're going to talk about today is some of the rules apply one state and don't apply in another state.
Correct. Typically, end-of-life decision-making is governed by state law, and each state varies in how they approach that. So, yes, it varies widely across the United States. Take, for example, doctor-assisted suicide. I mean, there are certain states in the country where that is permissible.
Right, I know that.
Florida is not one of those. In Florida, it is murder. So just be aware of that. But in certain states, you can do that.
And the states that can do that, off the top of my head, I would say California is one.
I am not sure about California. I know Oregon is the big one. Mm-hmm. Yeah, they were the first.
Kerry, the untalkable part of the panel so far today, is nodding his head like he knows something. What were you nodding your head about?
Well, I was just thinking about the fact that since we have so many people who move to Florida, they say there's over 900 families a week that are moving into Florida. So our population, that's a week moving into Florida. So our population is growing exponentially. And I know, as we've talked about this over the time, everybody assumes that you move from one particular state to Florida, that the rules are the same. And as I've heard you and Bill talk about on many different shows, you have to make sure that you understand what is permissible in Florida, because it may be quite different than what was the case in your home state. And of course, on this particular topic, it's going to be a state like Oregon or something that leads the way on an idea like that. And so that was the other thing I just wanted to throw in and remind listeners, because when you guys were talking before about having that Bill has been a resource that you guys have worked together with for so many years, I wanted to remind listeners that any of these shows that you hear or seem interesting to you, you can go to our website at helpingseniors.brevard.org, and you can hunt down any show. Just type in search by topic, and you'll see shows that Joe and Bill have done, both radio and television, on everything from guardianship to preparing your own finances to advanced directives. I mean, the list just goes on and on.
Yeah. So now, Bill, it's finally time for you to make your debut and talk about what you really wanted to talk about today.
Well, I wanted to talk about the name I forgot earlier, and that was Karen Ann Quinlan. That was the Karen Ann Quinlan case.
I remember that case.
So, yeah, we wanted to talk about advanced directives and what that means, and probably the first starting point would be, what are advanced directives? Mm-hmm. Advanced directives include a class of documents where you designate in advance of you becoming incapacitated who you want to make your medical decisions and what course of action you would like to take, a physician or a hospital to take in certain circumstances. So in advance of you becoming incapacitated, you lay out your decision makers and also who you want to, or what course of action you want a hospital or physician to take. So those documents, the first of those, we call it a designation of healthcare surrogate, and that's a document where you spell out who you want to make your healthcare decisions once a physician denotes in your medical file that you are unable to give informed consent. Recently, within I think 2 years ago, you could now also check a box off if you want them immediately to have that power, so you don't have to wait on the physician to denote that you are unable to give informed consent. The second document is a living will. That is your end-of-life decisions, basically whether or not you want life support continued. If you're incapacitated, meaning you can't tell the doctor or the hospital, and if you're in one of three states, a terminal condition, an end-stage condition, or a persistent vegetative state. Usually on the living will, you also denote whether or not you want a feeding tube, the artificial administration of food and water. The third document that would fall into this class would be the do not resuscitate order. That is a document that you get from your doctor has to be on that yellow paper, and you and the doctor have to sign it, meaning when they go to revive you, it has to be presented to them, and this would prevent them from bringing you back to life. So I frequently get asked, what's the difference between a living will and a do not resuscitate order? With a living will, think of ventilators, feeding tubes, pacemakers, but for the device, you would die. With a do not resuscitate order, think the paddles, that you've already died, but you don't want to be brought back to life. So that's the primary big three advanced directives. Sometimes when people move here from other states, we see a document called the Durable Power of Attorney for Health Care. Those do work in Florida, even though we typically use a designation of healthcare surrogate. So combined, those are what we call advanced directives.
Let me ask you a question about that then. Since you mentioned, you threw that little word called pacemaker in there.
Right.
And you talked about do not resuscitate. And let's say if a person has a do not resuscitate form and they have a heart attack, they're taken to the hospital, would the doctors use the paddles on them and try to bring them back?
Not with the do not resuscitate.
You know, I could probably try to make some arguments there because
I had some people in my office who were relatively young people, and they were talking about doing a do not resuscitate, and I went, whoa. I said, you don't want to do one of these. I mean, what if you're in a car accident and your heart stops? Obviously, you're young. You want them to use the paddles and bring you back to life.
Right. That's what I'm thinking.
You don't usually do a do not resuscitate order until you're, fairly, either in some sort of physical or mental incapacity way down the road. This isn't something that young people do. Now, young people obviously should do a living will and a healthcare surrogate. But the do not resuscitate is something you really hold off until, you're basically at the end of a disease progression or, you're terminal with cancer and you don't want them to keep bringing you back so you suffer more.
Yeah. Well, that's exactly, Bill, why radio shows especially, as opposed to television shows, radio shows, when you're talking live about a topic like this, and you say something, and then you got people like Kerry and I that we've asked questions of attorneys over the years so many times, and that it's like different strokes for different folks. My gosh, I'm 85, but I would like to think that. I would prefer for my wife to make a decision because she knows me,
right?
And she knows what she thinks I would like to have done, and depending on what the situation could be, I would trust her to make the decision.
And you could do that. You could not do a living will and simply leave your end of life decisions in the hands of your healthcare surrogate. There is a procedure where a healthcare surrogate can go through and terminate life support.
But again, it just points out the need for people to go to seminars. Like, if you got a judge, you've got a guardian there, you do guardianships, you do all these documents we're talking about, and it's never too late or never too early to start your planning.
Well, let's talk about what happens if you don't have the documents.
Okay.
If you don't have all these people in place, you run into, a buzzsaw, so to speak. There is a statute called the Healthcare Proxy Statute in Florida that says, if you don't have any advance directives naming a decision maker, the first person we're going to look to make medical decisions is your guardian, if there is one. If there's no guardian, then we're going to go to the spouse. no spouse, then we're going to go with a majority of the adult children. If there are no children, then we're going to look at the next closest relative. And if there is no next closest relative, then we're going to go to the next best friend. And then the last stop is the hospital can actually seek out a social worker to make those decisions, as long as the social worker doesn't work for the hospital. It has to be an independent social worker. So that's the pecking order of people who would make your medical decisions for you in the absence of a healthcare surrogate.
Just hearing you recite that litany of people is enough to scare the hell out of me and get me to go to a person like you and have my documents all lined up the right way, because I agree with some of the people you got, and they're making decisions for me, but for the majority of them, I don't want them making my decisions.
Well, let's go back to the context of the Shivo case. She didn't have any of these documents. So it ended up her husband filed for guardianship. He got awarded guardianship. And then at some point in the guardianship, he petitioned the court to terminate life support. And since she didn't have any documents that espoused her wishes, the part of the debate was, what would she have wanted? And he testified that she had told him she wouldn't never want to live like that, and that being a vegetative state. Her parents, I think, testified otherwise. And then there was a huge argument about whether she was in a persistent vegetative state or something called minimally conscious. And that went back and forth. And eventually the trial court found in his favor. That was appealed to the District Court of Appeals, and then that was eventually appealed all the way up to the Supreme Court of Florida. But and they sided with him the whole way, so he was able to terminate the life support. Now, wouldn't it have been much better if she just put her wishes down on a piece of paper and instead of having that whole circus going on?
Well, isn't that one of the points that's been impressed on me as I've listened to you guys talk about these topics, is that the process that you just described, where he had to actually obtain a guardianship, all that, isn't that just an evidence of that if you had your paperwork in place to begin with, that might have short-circuited that whole process. And I understand the paperwork. We're talking minimal cost versus the tens of thousands that setting up a guardianship could potentially entail.
That case is probably hundreds of thousands.
Wow.
Yes, and you're correct. I mean, if they had a healthcare surrogate for the medical decisions and a durable power of attorney for financial decisions, they wouldn't even have a guardianship. You're right. So that could have all been avoided. And then, obviously, last time I was here last month, I think we talked about the case in Orlando, about the guardian signing do not resuscitate orders, and that's all blown up in the media. There's not a week that goes by without some other story about this particular person. And you know, there are two sides to every story. And so not everything you read in the news is true. We certainly haven't heard the Guardian side of the story at all.
And that's a fascinating story, by the way. You can hear it. You can find that one. That's archived on the Helping Seniors website. Make sure you tune into that, because I think that's a lot of what's coming tomorrow in the session too, right?
Correct. We'll be talking a lot about that tomorrow. You probably won't hear the judge talk about that specifically, because there are some cases that this guardian had in Brevard County.
Oh, wow.
And so they probably won't talk about specific cases. They would just talk more in generalities of what they're going to require down the road.
And another thing I think, we're about ready to wind up, take our mid-show break here, but when you talked about Judge Davidson is a really down-to-earth person. I know her personally, and you don't really get a chance very often to ask a judge who is as experienced as Lisa is a question, any type of question. That's the really advantage of attending something like this, Bill. So I think that the what people can gain by going to this seminar tomorrow is fantastic, because I'm going to try and go there myself. I have to, whenever I say something like, I have to check my schedule, because I have to work it around all my medical appointments. So with that, we're going to take our mid-show break here, folks, and when we come back, we'll get Bill to talk a little bit more about some of these documents and what can be done in the state of Florida. And the one question I want to ask Bill is, and let me think about during the break, is if you spend X amount of dollars to put all these documents in place, how it might mitigate against you spending many thousands of dollars in a guardianship. And that's extremely important to understand. So with that thought in mind, we'll take our mid-show break.
12:33 in the afternoon here on 90.3 FM. It's Wednesday, Joe Steckler Day, helping seniors of Brevard. And once again, here is the host of your show, Joe Steckler.
Thank you, John, and welcome back to the second half of our show, listeners. And I enjoy doing a show like this with Bill and Kerry, because Bill sort of brings to the show an easy way to understand some very, very complicated legal situations. And the sad part about it, and I've talked to Bill about this so many times, that because a person is an attorney doesn't mean that person is going to be able to do the job for you. You have to feel comfortable with your attorney, just like you have to be comfortable with your doctor. And there are attorneys and there are attorneys. And I know from personal experience in working so many years and answering questions for people, and I've done this for 30 years, folks, I got a pretty good handle on what people ask and how they get hurt. I can tell you that I have never felt uncomfortable in recommending anybody to call Bill Johnson's office, 253-1667, and ask if they can handle his case. I usually have a pretty good idea, and sometimes he surprises me by what he will do and what he won't do. But having said that, good attorneys are extremely important, and I just want to make sure that people know that we have some wonderful sponsors, organizations like Vitas Hospice, and they're one of the sponsors, I think, for the show tomorrow, right, Bill? Or you got somebody from Vitas Hospice on, or their general manager?
We have, the sponsors are the Brevard County Bar Association, Florida State Guardianship Association, Space Coast Guardianship Association, Krasny and Detmer, and Zon Beachside. But we have somebody from the Vitas in the roundtable discussion.
And that's important, folks, because Vitas Hospice provides the end-of-life care, which is so important for you to understand that if you have Medicare, if you have certain types of insurance, what's covered, what's not covered. But what a lot of people do not understand, and these are the types of things that you can find out by going to one of these seminars, is that if you are on Medicare and you have secondary insurance, that you're not going to be charged anything, to my knowledge, for being in hospice. And hospice is going to cover everything. It's going to cover all the medications you need. It's going to make it easy for you to make some decisions. And while it's painful to think about not being here with the ones you love or the ones that love you, at least try to go out in style. And by meaning that, make it easy for the people that you leave behind you, because you can't change the fact that you're going to die. Yeah, we're all going to do that. So make it easy for the people that you love to make the decisions for you. And I know that Kerry, I'm sure Kerry feels the same way. And I think that by virtue of the fact that Bill does what he does, he feels that same way. But go ahead, Bill.
Well, I was going to say at least the healthcare surrogate and the living will. Generally, if you go to the hospital, they have you fill them out if you don't have them at the hospital. You can get them from a lot of physicians' offices have them. There is a wonderful document called the 5 Wishes that is available. You can get that on 5wishes.org. and I believe they charge $5 for it. And you can either have them send you a printed version of that, or you can do it online. But that basically, the information in that document is a healthcare surrogate and a living will all in one document. Again, that's 5wishes.org. So there are ways to get these documents for free or at a minimal cost and get yourself covered.
But here's a question. So we were talking a little bit during the break because during the break we were talking about the fact that what I have understood over and over is that taking some time to get things done correctly probably could save tens of thousands because, we think we know what we're doing if we go, we were joking at one point. I heard you guys joking about somebody goes down to Office Depot and pulls a form, but we don't have the experience to know how to fill that form out correctly. And we can make mistakes simply because we just don't have that experience.
Correct. And not all of the forms that you get at an office supply store, for example, are updated.
Or even the hospital. If they hand you in here, you got to fill this out. Now you're under pressure and you don't know how to do this correctly.
Very true. And we found when they changed the durable power of attorney statute, we kept getting people who had these forms, even from online services, that had not been updated. And subsequently, they did not have the powers they thought they did because they didn't comply with the changes made in 2011.
Yeah, you explained that even if somebody says, no, here's my power of attorney, I can do this. I remember you and Joe, there's a TV show online that you guys did together where you were talking about that you have to explicitly state the powers that you are designating, and so this old blanket form just doesn't necessarily cut the mustard.
Correct. I just saw one from Illinois that we're going to have to redo because it's a check-the-box format. New York State has a kind of check-the-box format, and those don't work well in Florida.
See, and I don't think that most of us understand that we're guided by the state's law when it comes to this. So we say, well, we moved in from this state, or we came from up north, or came from out west, and we're going to retire in Florida. And so we think, well, we had everything correctly set up where we were from, but we don't know if that's applicable now here in Florida.
I think as a safety measure, you should always have your documents reviewed by an attorney in the state you move to, just to make sure there's no peculiarities. For example, people do trusts all over the country, and they move to Florida, buy a house, put it in the trust, and think they're done. And there's some magical language that has to be in the trust to make you eligible to get that homestead exemption. And there's also some other language that needs to be put, waiving the Florida constitutional provisions for devise and dissent. I'm not going to get into all that, but you could, by doing things like you did in your old state, you could create a huge title problem,
right,
as well as not be eligible for that tax deduction.
So what if you're like, I would say, like an ordinary person, and you don't consider yourself super rich, and you say, well, you're talking trust, you're talking all these things. At what point does a person say, listen, I should sit down and get some professional advice?
I don't think it hurts to do it at any time. We don't charge for consultations. I know there are a whole slew of people out there who do what I do who don't charge. So, I mean, if you're just curious and want to get an opinion as to your documents or even a second opinion, you can go, find an attorney who doesn't charge for a consultation.
So I know I've heard, Joe, you said that so many times, is like, if it's not going to cost you to sit down and get pointed in the right direction, why would you not do that?
Well, exactly. I just been holding my tongue here, listening to you two talk. But Gary, sometimes we don't like to talk about cost, or Bill. Sometimes we don't like to talk about cost. We don't like, but can you explain to our listeners what the average cost from a fair, knowledgeable elder law attorney, like you did the trust for my wife and me, and I ask you, are all the documents that we're talking about today covered in a trust? And you said yes.
Well, usually they're covered in a trust package.
Okay, package.
Which would be a will, a trust, power of attorney, healthcare circuit, living will. So,
but that's what you do. You include all that in there. So what if somebody goes in and they're 30 years old?
Well, we charge like $1,250 for a married couple.
$1,250.
Right, and we're middle of the road for Brevard County. There are cheaper people than us, and there are considerably more expensive people than us.
You're darn right. I know that there's somebody charging an arm and a leg, and I know some of the attorneys in this town charge $12,000, and I've had people tell me that, and that is not right, and that's the type of thing. And I'm not going to. I would never mention names on the show. I won't do that. But I have never pointed anybody that's asked me a question to anybody I thought that was overcharging. I can't do it. I won't do it. And as a result of that, I've had so many calls over the years where people say, I would like to talk to you. And an hour later after you've talked to somebody, you try to figure out, and I'll sometimes say to my wife, what in the world should I do? How can I handle this? What's the best way to go about it? There's so many questions that come to my mind, Bill, when you get into the law business.
Well, I was going to say, we just now are talking about advanced directives, and I told you one way to get it for free. I told you another way to go online and get it for $5. So, I mean, you certainly could save yourself a lot of money instead of seeing me and at least get the advanced directives part of this done.
But the flip side of it is if you took the moment and used it to assess where you sit with all of this information, because I guess the key takeaway is if you spent a certain amount of money to get these things professionally reviewed, because again, like I said, my fear as an individual would be I wouldn't have expertise, so somebody could hand me the form and I wouldn't know if I'm giving the correct information or have thought about the questions that I need to answer before I put answers down. And so when you're talking about the minimal cost to put together your paperwork properly versus what you might run into if you were forced into a guardianship.
Well, that's a great example or statement, because what we've seen in the legal profession lately, or with regards to legal documents, is this proliferation of online services that will do these documents for, a fraction of what a lawyer charges. And I can tell you probably 50% of the will and trust documents that come into my office, and that I'm not kidding, 50% have been executed incorrectly. People have these trust documents and for whatever reason they sign their name and they think the witnesses are optional, even though there's 2 spots for witnesses to sign. We see that all the time.
And that's probably
all the time.
That's probably also assuming that even everybody in that stress of the moment when these documents need to be used is in agreement. And Lord forbid, what if one person has a different idea than the other person, and now if the document's defective, haven't you really backed yourself into a corner?
You've really made a mess. And then the other thing that you can't tell with online services is who is actually doing the document. So, when I get somebody in my office, I take great pains to make sure they're not being unduly influenced and that they have testamentary capacity. When somebody is out there doing something online, I have no idea who's in the room holding a gun to their head. So I have no idea whether or not they even had capacity to do the documents. Wow. So you run the risk of having everything thrown out. Mm. So it's hard for, with the online, a lot of times we find, especially with people who are susceptible, meaning they've got diminished capacity, that maybe all these documents are being done at the request of one child. Right. And then you go back and you find out they got 4 loving children, and all of a sudden, somebody's got their name on the bank account and money's missing.
That's really the complexity of it, and why it would make sense to have things done properly, incredibly, because you're making it simpler not only for yourself, but especially the people that you care about most.
Correct.
One thing I wanted to ask you, Bill, this morning on the show or this afternoon, the difference between, and it's might cause some problem, but I hope not, the difference between a living will and a last will and testament.
Well, a last will and testament is a testamentary document whereby you leave your assets to someone or to a trust or something, and you nominate somebody to be a personal representative. That's Florida's fancy word for executor. And you spell out, who gets what and who's going to be in charge, basically. And then wills go through the process known as probate. And we talked just a little bit about trusts. Trusts avoid probate, and so do beneficiary designations and certain types of joint ownership. However, a living will is a healthcare document, not a financial document. And a living will is your end-of-life decisions, whether or not you want life support continued, if you're incapacitated, and either in a terminal condition, an end-stage condition, or a persistent vegetative state, and whether or not you want a feeding tube if it would only prolong the dying process.
Okay, and when I was doing some research on the internet last night, I came across several different uses of a document that we've talked about that's so extremely important, and it's something I would like for you to discuss this afternoon, is the durable power of attorney. And I always thought of a durable power of attorney as being just that, a durable power of attorney. But on the internet, I picked up where they got something they call the medical durable power of attorney.
Correct. Durable power of attorney, you can grant people powers to, and typically in Florida, we're dealing mainly with financial powers, because we have a separate document called the designation of healthcare surrogate. Other states, they just have everything done under the durable power of attorney statute, and they create a document called the durable power of attorney for healthcare. Durable means that the document continues on even after the person who made it becomes incapacitated, which of course would be very important if it was for healthcare. And so subsequently, the main difference in the application of it is, as I mentioned, generally a designation of healthcare surrogate doesn't become effective until the doctor denotes in your medical file that you are unable to give informed consent, whereas a durable power of attorney for healthcare is effective immediately. And the other thing I pointed out is a few years ago they changed the healthcare surrogate statute now that you can actually make a healthcare surrogate designation take effect immediately as well.
Yeah, in the course of talking today, you cited a case where a young couple could be in a car accident, and they could be living here in Satellite Beach, Florida, traveling in New York, and they have a car accident. They're sometimes the family gets notified quickly. Sometimes it's impossible. They might even not even be able to find out who they are. But the decisions that are made by doctor. What am I saying? You know what I'm talking about?
What I was going to say, that's a great point, because all of these documents we talked about, a copy of them should be in your medical file. So you should give your primary care physician copies of all these documents, as well as, to any other specialists you're seeing. That way, if you're in a car accident somewhere, hopefully your primary care doctor somehow gets in the loop, and these documents somehow become available to the hospital.
Okay, now, we talk about doing these shows. We've done this type of show. I can't even count how many times we've done it. That's the first time you've ever said, to my knowledge, that the primary care doctor should be given copies of these documents.
I've said it before, Joe.
And I don't remember.
And Kerry's got the tape to prove it.
Yes.
Well, since mine's the best memory, I But it brings us out to a point that no matter how many times we talk about these things, there is always something extremely important to learn, because the law changes these documents. And what my greatest fear is, and then Kerry cited it earlier, with 900 families moving to Florida on a weekly basis, that a heck of a lot of those people probably need the documents that we're talking about now. And if they come in from another state, they have no knowledge that they're now under Florida law. And it's frightening, because I've been in the information business, as has Kerry, for a number of years, and trying to get people to be made aware of what they need to do with the type of documents we're discussing today is frightening, because it's so hard to get the word out with the decline in newspapers. People don't even read the newspapers. They look for news on their iPhone, and they're not going to sit there and look at the stuff that you and I are talking about today. They're going to look for what's the latest score with the World Soccer Championship, or who won a Wimbledon or something like that.
Yeah.
Sure.
That's how it happens.
I got you.
Yeah.
That's true.
I know.
I agree with you.
Yeah. Yeah, sometimes you're really good with those one-word answers.
Yeah, well, I hit the ball back over to your side of the court.
I know. Okay, Kerry.
Well,
okay, no, this makes a good point, because this is extremely important for people to know the good points about Facebook, Twitter, and all these things, if they're used the right way and not constantly trying to impeach somebody But if we use them to help people, we can accomplish something.
And the one thing I would generally say, if you're looking at anything on the internet, make sure it's current, because there are plenty of outdated materials on the internet that have no applicability to what's going on today. 2, make sure it's from your state.
Yes.
States, as I mentioned, these documents are all governed by state law. Each state varies. So if you find out something about power of attorneys in Colorado, it may not be applicable to Florida.
Yeah.
Those are 2 really big, important things you need to look for.
We have a joke around the dinner table when somebody will bring something. I was reading today on the internet. And so, well, if it was on the internet, it must be true,
right?
Because they wouldn't allow you to publish anything on the internet that is not true. And one of the things, because
that's a great point. And number 3, verify.
Yeah.
Yeah. Don't just take one web page's word for it. Go look at multiple sources.
And that's really the key. That's why at Helping Seniors at Brevard, we're so committed to getting information out on digital platforms, in addition to all the things that we do on print and in radio and in television. That's why we have the Facebook, the Twitter, the LinkedIn, we even have an Instagram. So we've got all these things for Helping Seniors, where our object is to reach the 250,000 plus seniors, as AARP would call it, over the age of 50 in Brevard County, wherever they live, Miko to Mims.
When you speak about the internet, I just have noticed in the last 2 weeks, I've seen between 12 and 15 applications for our newsletter, where people want to get our digital newsletter sent to them. And the last statistic number you gave me, Kerry, was 1,449 people that are now on our email list. So what we can do is on Facebook or on Instagram, we can reach all those people.
Yes.
And tell them about what we talked about today, telling them that they can go to our website, and within 2 or 3 days the show is up, and people can listen to everything we talked about. And there's so much. Getting people to understand there is access to really good, verifiable information is extremely important, Bill.
I totally agree, and getting good information is also.
Okay, I'd like for you just to give the phone. I can't read. I was going to do it. I can't read that darn phone number on that sheet you gave me for that. For the thing.
Oh, yeah, you would call Robin at 321-720-5961 if you're interested in going to the special meeting of the exploring the statutory obligations, DNR, life support, end-of-life, hospice, surrogate decision-making, guardianship, and best practices.
Yeah.
And if they're interested in getting in touch with you to get to just learn more about what maybe they should do, or at least take a free consultation, how do they get in touch with your office?
They can reach my office at 321-253-1667.
You know your own phone number.
I do. And I didn't even have to look it up on the cell phone.
I know it too, and I don't have to look it up. I know your phone number and Jennifer Helen's phone number.
I was going to say, Joe, back in your day, how did you get the news?
Well, that's a good question. My little town.
Was it telegraph?
No, it wasn't. Actually,
just poking some fun.
Actually, when I was a little boy, we still had Civil War veterans that lived in my town in Kentucky, and we still had a hitching post in the street for the people to tie their wagons and horses up when they came to town on Saturday. And we had one guy worked for my grandfather, and his wife sewed him into his long johns in October, and he wore them for the next 3 months. The same set. And John is signaling me to get off the air. So I won't talk about the long johns anymore, but I will thank you, Bill, and thank you, Kerry, for being with us today. And I hope you enjoyed the show, listeners. And do think about attending that seminar tomorrow. And if you have a question, call us at 473-7770. We can answer your questions. See you next week.